thank you all for coming and having this experience that I know is a little bit different than what you read in your case books. These are how those cases make it into those case books. So I just wanted to briefly introduce the panel of the court. The attorneys, of course, know them very well, but our students might not. So the three judges on this panel are very well connected to the UC Law community. I'm very proud that this panel is here today. Judge Myers is an alum of UC Law, as is her grandfather, Judge Chase. And some of you have probably studied in the rooms that are named in their honor. Up 271 and 273 are named after Judge Myers and Judge Chase. Judge Bergeron, I joked with him, I'd say, well, the thing that we think puts you in honor is that your wife teaches here. Professor Bergeron, you might know, is the managing attorney for the Ohio Innocence Project, but Judge Bergeron also has close ties with UC Law, and he teaches a course every spring semester on state constitutional law. And then finally, Judge Zayas is working with the UC Law community because she is a member of the Dean's Advisory Board here at UC Law. So all three of these judges have devoted a lot of their time and energy into supporting you all, the students, and the UC Law community. So I'm very proud that they're here today to hear real live cases, but also to give our students the experience of seeing what it would be like if you were in the attorney's chairs arguing before these judges. So welcome, and I hope that you have a great experience. And to the attorneys and clerks who are here, thank you for redirecting your cars this morning instead of going downtown, coming here to UC Law. So thank you.
Good morning, everybody. Can you all hear me? Everybody hear me? Thank you. It is our great pleasure to be here today. Welcome to the First District Court of Appeals oral arguments. For those of you watching remotely, we are conducting our arguments this morning on the campus of the University of Cincinnati College of Law. I want to first thank Dean Whiteman for inviting us today. Thank you also to all the faculty, the staff, and the students, most importantly, the students who have come today to participate with us in the arguments. I also want to thank my colleagues for being here. It really is our pleasure to come to campus and conduct our arguments for the First District Court of Appeals. We have three cases that will be argued today. We are going to hear arguments. Each side has 15 minutes to argue. The appellant also gets a period of rebuttal time out of that 15 minutes. We then will take a 15-minute break, and I apologize if Dean Whiteman has already gone over this. We'll then have arguments for our second case, followed by another break, and then our third case will conclude with those arguments this afternoon. Late this morning, excuse me. It'll feel like afternoon. And then we'll have a brief question and answer period. So with that, we will get started. Council, I'm going to keep everybody's time today. And if you notice me looking down, it's because I'll be keeping it up here. I can't really see that clock in the back of the room. But our first case on the docket this morning is Butler versus TriHealth. Council, I'm going to let everybody introduce themselves. I will start with the appellant. If you will please introduce yourself to the court and to the gallery.
Thank you, Your Honor. My name is Scott Wolf. I'm an attorney on behalf of Tina Butler, who is the appellant in this case. May it please the court? Should I begin, or am I just introducing myself? I was a little bit unsure.
Introducing yourself, I'm going to turn to Ms. McCarthy.
I'm with the law firm of Weiser and Wolf, and we represent Tina Butler, the appellant in this particular case. Thank you.
Thank you. Ms. McCarthy, if you'll just introduce yourself.
Good morning, Your Honor. Hannah McCarthy on behalf of Appellees, TriHealth and Bethesda, and we are ready to proceed.
Thank you. Mr. Wolf, thank you. You will have 15 minutes to argue this morning. Would you like to reserve any time for rebuttal?
3 minutes, please, Your Honor.
All right. I will keep your time, and whenever you're ready, you may begin.
May it please the court, esteemed counsel, law students and faculties at the University of Cincinnati. My name is Scott Wolf. The issue today that's presented is that we believe the trial court erred, granting summary judgment when a genuine issue of material fact exists as to whether or not the hazard contained in the Bethesda Hospital parking lot was open and obvious. Appellant went to the Bethesda Hospital parking lot to visit her husband, who was in the emergency room on September 6, 2018. She parked her car. As soon as she got out of her car, she walked in front of her car on the pavement at all times, took 2 steps, and the next thing she knew, she stepped in a hole, twisted her ankle, and broke her ankle. With respect,
Is the analysis any different if it was just in the middle of the parking lot versus kind of obscured by the car?
well, I think a little bit, Your Honor, because there are cases that talk about by the time you enter the hazard, it's too late to avoid the hazard. In particular, in this particular situation, when she pulled into the parking lot, there's no testimony whatsoever or evidence that she wasn't paying full attention. But as soon as she turned around her car and took a step, there was the hazard. There wasn't any time to
Placement of the car.
No, I believe it was a hazard because of 2 reasons, Your Honor. One, it was dark, but not total darkness, but it was dark. So the parking lot was a temporary parking lot as they were building a new garage. So it was not well lit. Also, this hazard or hole, as we're talking about, was filled with the fine ground up pavement as a result of water runoff. So the actual hazard was the exact same color as the pavement. That's why in this particular case, we have 2 affidavits from the people that were there that night that claim even at looking at the hole, you still couldn't see it until you. So there's 2 testimonies on behalf, there's 2 pieces of evidence basically on behalf of Tina Butler testifying. First is her deposition. And I'd like to go over that real quick if I can. So during her deposition, she's asked what happened. And she says, so I'm walking in front of my car, I'm going to the walking path. And the next thing you know, I mean, I didn't see a hole. You know what I mean? I didn't see this hole. I didn't see anything, just a regular parking lot. Then in her affidavit, she does mention the fact about it sort of looked like an oil spill. But by the time she got to that point, she had been in front of her car and was taking her steps. So she was already in the hazard by the time she could even see what sort of looked like an old oil spill. But at no time is there any testimony in this file, in this claim, that states that Miss Butler was not looking where she was walking, that anybody, there's no testimony that actually the hazard was visible.
Let me ask you, if we accepted your argument is, I guess it's a latent defect in the parking lot and that the hospital should have known of its existence and either failed to warn or failed to remedy the situation?
That's correct. The hole, obviously there's photographs that were submitted, but all of those photographs were taken either with flash camera or during the day. But you can see from that the hazard that actually exists within the parking lot, which was there for an extended period of time because it was a result of water runoff. And all those fine particles inside of that hole or hazard was part of the pavement, which was the exact same color as the pavement, which is very similar.
Well, not to get ahead of your argument, but if that's true and the runoff was caused by a natural occurrence.
No,
mean,
the
they're not
runoff, I believe,
responsible,
was
are they?
caused by the fact that this was a very old parking lot, which is why they were building a brand new parking lot and just decided not to correct whatever problems were in that parking lot because we have this brand new parking garage going.
Let me go back to your argument about it being dark. If it was in the daylight, would this be an open and obvious condition?
I think it's clear from the photographs that if it was in the daylight, it would be, you would be able to see it, but it wasn't just the dark.
But that, let me stop you
But it
there.
wasn't just the dark, Your
Okay.
Honor.
Let me stop you at just the dark. If it were just the dark, lighting, don't the cases hold that darkness is not an attendant circumstance?
Well, the cases hold that darkness you should be more careful in. I think that's really the true holding in those cases. But in every one of those cases, there is testimony that the person could have seen the hazard, wasn't looking to see if they could see the hazard, and it was observable. And to me, it's very similar to the Asher case, Your Honor, the Asher versus Glenway real estate case, where in that particular case, the patron did not did not see the hazard until they opened the door. And then that leads you to sort of the Hacker case, which talks about, in that case, the curb that she fell on was the exact same color as the pavement. And it's almost identical to this particular situation where my client gets out of her car to go visit her husband who's in the emergency room, turns her car, turns the corner around her car, because that's the path that was available to her, always on the pavement. And by the time she took a step, she was in the hazard. It was not observable. You have two affidavits from two people who were there that night to say it was not observable, even looking at it. When Elizabeth Shepard got there, she wrote an affidavit. That wasn't mentioned at all in the judge's.
Part of your argument is that there isn't a reasonable expectation to discover.
I think they.
With regards to this hazard.
Correct. I think it's, when we really get back to what the duty is
Are
of.
you also arguing attendant circumstances?
Well, I think attendant circumstances, I'm a little hesitant to go that route, because I think in attendant circumstances, what those cases really stand for, at least from my reading of them, is that people were distracted for one reason or the other and didn't see the hazard. In this case, and I think it's what's really unique about this case, if you really look at the evidence, in my personal opinion, there's only three pieces of evidence. There's two affidavits and there's the deposition. That's it. As far as was it discoverable or not. And in those two affidavits, both witnesses maintain you could not see the hole. And during her deposition, there was never any question where she said she wasn't looking, where she was walking, or was just distracted by anything. At all times, my client has maintained she was looking out for her well-being as an ordinary person going to a parking lot would have done.
What I find interesting about your argument is you're talking about her parking the vehicle and then immediately encountering the hazard with no opportunity to be able to observe the hazard. That's what I understood.
That's correct.
Argument. Okay. So can you point to any case law that looks at open and obvious as something that is circumstantial? Because your argument is circumstantial.
Well, I'm not sure I know how to exactly address that, but I think that there are two cases. I mean, clearly the Asher case talks about not being able to see the hazard until it's too late. And
in those cases you cited, there was a door opening. So it appears that anyone opening the door would be equally situated with regard to the hazard.
And in the Hacker case, again, which is First District Court of Appeals case, Hacker fell on a curb that was the exact same color as the pavement. And the Court of Appeals found, again, because it's a summary judgment issue, considering all the facts that are most favorable to the non-moving party, is there an issue? And I would maintain when the only three pieces of evidence you have in your file as far as this particular issue goes, or the two affidavits and the deposition, certainly taking those as the only evidence, there has to be at least, and using those in most favorable light to the appellant, there is an issue of fact, whether or not she could have seen or whether it was open and obvious, the hazard.
But isn't the burden on you?
Well, I think the burden is on me today. I think it's a de novo hearing.
With regard to the summary judgment.
Okay. Yes, but I think when I'm the only one that has any evidence saying that it wasn't open and obvious, and there is no other evidence that to me is in the file saying that it was open and obvious, is really what's different about my case versus a lot of the cases that I've read with respect to the slip and fall area.
It isn't the reason you're saying the only evidence is because your argument is that the photos weren't properly authenticated?
Well, thank you. And I would like to address the photographs if I could.
And you have 3 minutes left to do that if you want to reserve 3.
Thank you. But under evidence rule of Ohio 901, okay, there's certain ways to get photographic evidence into a file. And photos can be used for two things. One, they can be used to sort of describe a witness's testimony And in this case, there's a hazard. I think that's fine. But when it's trying to prove the exact fact of what it needs to have some sort of foundation that this photograph we're submitting accurately depicts the scene where she fell at the time of night in which she fell. And there is no evidence of that on any of those photographs.
Well, can't it also be, it is what it purports to be? It purports to be a picture taken of a hole in the daylight that isn't, the conditions weren't exactly the same. It's still authentic. It just might not be, it might be a weight and sufficiency argument.
I would maintain that that is a good argument to say there's a hazard in the pavement, that you can see it, but I don't think it's a good argument to say that it doesn't change that it still has to be observable by the reasonable person.
In the dark without flash, and to establish for the court what it looked like.
Well, I think that's why I don't really have one, Your Honor, because when you took a picture in the dark, it was just dark. Okay. And so then you revert back to the only evidence you have in this case, which is the deposition of Tina Butler and the 2 affidavits. And if you take those 3 pieces of evidence, it clearly presents an issue that it might have been not observable at that time, and therefore summary judgment was inappropriate at this stage.
You have 1 minute left if you'd like to reserve 3.
Thank you, Your Honor. Again, as I have stated, I think the trial court, they failed to take into the consideration the Shepard affidavit. It talked a lot about darkness, but darkness is not a total denial of a claim like this. Darkness just says you're supposed to be more careful. In every one of those cases, there's testimony saying either the injured person wasn't looking where they were going or was distracted. And in this case, the only evidence we have is the 3 pieces of evidence. All of them say you could not see the hazard at night, even looking at it. Again, nothing has changed about the duty that's owed to a business invitee. The duty is, if there's an unsafe condition, you need to warn them if it's not open and obvious. That didn't happen in this case. My client was just parked her car, took 1 step around her car and broke her ankle. And it wasn't obvious because we have the only evidence we have is you couldn't see the hole at that time due to the pavement in the dark. Thank you.
Thank you. Ms. McCarthy, you will have 15 minutes to argue.
May it please the court, Counsel Wolf. We're here today because the plaintiff has appealed the dismissal of their case by summary judgment. However, the trial court was correct in granting our motion for summary judgment because the depression in the parking lot was open and obvious. Despite appellant's attempt to argue that the darkness in this case was different from the darkness in every other first district case that holds that darkness and dim lighting is not an attendant circumstance. The darkness here is still not an attendant circumstance. Because
It's situated such that does the location
no, the location of the hole does not change our analysis because whether the plaintiff had taken 1 step out of her car into the parking lot or 50 steps, the duty does not change. Business owner does not have a duty to protect invitees from open and obvious conditions. Well, I would argue that because she chose to walk in an area that might have been partially obscured by the car or the shadows of the car, that heightens. Well, in dark and dim lighting, she has a heightened duty to watch where she's walking and be cognizant of the ground in front of her.
Let me ask you this. You refer to it as a depression. Let's say it was a 20-foot deep hole that was 5 feet in diameter. And it's dark and you can't really see it. Would your argument be the same if somebody fell into that hole?
No, that would certainly change things, but the depression here,
Why would it change things?
if you truly could not see the 20-foot hole, then
Yes.
that would change things. But this depression, she saw that there was obviously a difference in coloration. She thought she saw an old oil stain. It was a 2 to 3 inch depression. And she recognized what she saw in front of her. She just didn't recognize that it was a depression as opposed to an oil stain.
Is this parking lot, I don't think this is in our evidence, so maybe it's an unfair question, but is the parking lot torn up? In other words, are there depressions all over it with loose gravel and loose pavement? Or
No.
was this the only one?
No, Your Honor, there is no evidence in the record whether this is the only depression in the parking lot, but council has said that this was a temporary parking lot, this was an old parking lot, and neither of those things are true. This is just a true parking lot at the hospital.
Thank you.
So in conclusion, this was an open and obvious condition. It was a 2 to 3 inch deep depression in a parking lot, which the plaintiff did recognize as darker than the rest of the pavement, as evidenced by the fact that she thought it was an old oil stain. Given that it was open and obvious, a business owner does not owe a duty to invitees to warn them of open and obvious conditions. And every case in the first district and throughout Ohio is held that darkness is not an attendant circumstance. Given that appellant's counsel has not presented any other arguments of any attendant circumstances, he has not met his burden of proof that we owed a reasonable duty of care and breached that duty.
Address, if you will, one final point, and that is his argument, and maybe you already addressed this a little bit, that under the Asher, it's like the Asher case, that the danger wasn't appreciated until she was upon it.
In the Esterman versus Speedway case, the court tells us that a plaintiff does not have to actually see the condition before encountering the condition. It can still be open and obvious even if they don't see the condition before encountering it.
His argument is more about whether a reasonable person would have seen it, or that there was an expectation of discovery. That's
Well-
really what his argument is, which is a little different than the cases that you're citing with regard to darkness.
Mhm. I think it's important to note that she did see the condition before encountering it. We have that evidence from her deposition.
She was just wrong about what she thought it was.
Correct. If there are no other questions, then that is all we have.
Thank you.
Thank you.
Mr. Wolf, you have 3 minutes remaining.
Can you start where she ended, which is the issue of that she had the opportunity to observe it. However, she was mistaken as to what it
Yeah,
actually was.
Yes, Your Honor, thank you. Again, there are cases out there that talk about that once you enter, sometimes you enter a hazard, it's too late to appreciate what you're stepping into. And that's this case. When you walk around your car, you take one step, it was right in the middle of her, it was right there. And so she wasn't able to see it. I did want to bring out that, the court does have, there's also the Martin case that the court talked that the first district has.
I understand what you're saying. What you're saying is, although she had the opportunity to observe it, she didn't have the opportunity to appreciate what it actually was.
I think she actually observed it at the time she was already basically in the hazard. And when I'm saying she observed it, she took one step around her car and took a step and there it was. So I don't think she had an opportunity to appreciate that it was a hazard. And I don't think she actually knew that what it was. But by the time her foot was going down, that's what she observed. So it's too late to appreciate the danger. And I think the whole issue
Like
of
the argument, as I hear it, is because she had stated that she thought it was an oil spill, that cuts against your argument.
I hear that, but by the time she saw it was an oil spill, it was too late. Her foot was going down into the hole. And then I think when you look at the other evidence that goes,
Clear from the record?
I think it is when you look at the photographs and you see see where it is compared to her car, you can tell she took one step and she was in the hole. So I think you could sort of take judicial notice of that. just from the photographs that you have seen where the hole was compared to her car, that's all it would take is one step.
You have about 30 seconds remaining.
Thank you. Again, a duty to the business invitee is to maintain a property in a safe condition. And the reason for that is really, if it's open and obvious, the reason open and obvious we have that is because it puts you on notice of a dangerous situation. In this particular case, she was never put on notice of a dangerous situation. By the time she entered the hazard, it was too late. The only evidence you have of whether it was open and obvious are two affidavits in her deposition testimony, all three of which maintain you could not see the hole at nighttime due to the fact that it was crumbled up with the exact same color pavement that the pavement that's what was in the hole, which is, again, I think part of why she was unable to appreciate the danger in which she found herself in.
You are at your time.
Thank you. Thank you very much, Your Honor.
Counsel, thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. That will conclude our first argument for the First District Court of Appeals.